The other thing, of course, would be the convergence of regulatory and accounting concepts, which I've dealt with. Now, again, the template will be, in future, would be the three: the stable systems, efficient markets, and effective consumer protection. Now, the other thing would be this: the convergence of ideas in all financial institutions would actually be based on the three-pillar approach, which in fact the Basel Committee, of course, has pioneered with Basel II. Now, in fact, has pervaded all financial regulation, which is, of course, you have to have sufficient capital, a buffer for the black swan event, essentially. And then, of course, the buffer to cover your losses. And then, of course, you have to have very good internal controls and corporate governance. One of the issues which Paul touched on in the survey, that all the members of the CFA regard as important: good corporate governance, good internal controls, and of course, good disclosures. Very interesting thing about disclosures is that people do care about disclosures. And in fact, you will find law firms, in fact, which are partnerships. In fact, some of the major law firms around the world have actually published their financial statements in their website, actually. And law firms don't have to do that. But quite many of them now do that because they want their clients to know how much money they make, how strong they are financially, so that they won't fold up, in fact, in the middle of a big case, and they don't go bankrupt, for example. So these are the important things about disclosures, which people, some of these, you might say, the benefits of good disclosure. The impact on the markets then would be on corporate governance, would be very, very important. Boards of directors now have to really understand what the financial institution does, and in fact, be able to really grasp and understand its risk and to give direction to the management. So it's not easy now being a director of a financial institution. It will have impact, these regulatory changes will have impact on asset management and investment advice in a very, very big way. Now, some asset managers are sufficiently big to become systematically important. And the FSB regulators are looking into that. So I would imagine some of the really big ones, such as State Street, for example, or Mundi, for example, might be considered to be, in fact, systemically important, and they will have, in fact, capital requirements. They will have, in fact, reporting requirements put upon them. I think product regulation will become far more important. Now, at the moment, one of the big problems, of course, with the Lehman issue is that it didn't come through, in fact, prior product approval. In fact, because it was a company instrument, it was actually a security. It could actually be registered as a prospectus and then sold. Now, the question then would be, do you need to have product regulation? It's a very, very difficult subject, and it is, in fact, always the dichotomy between regulation and financial innovation. And regulators always have to grapple with this. And I think one of the things that perhaps regulation will have to consider, particularly financial regulation with difficult and complex instruments, is to really take a page from the way that other regulation is done. For example, like the medical industry. I'm not saying that, in fact, financial products should go through an FDA process, for example, which takes 20 years, which is impossible. But at least, of course, you will have to have, in fact, I think, consumer testing, essentially, as part of the issues, what part of the testing of that instrument. For example, focus groups, in fact, to see whether people could understand them and so on. Now, I would think that even if there is no prior product regulation on products, there will be, at the moment in Hong Kong with the ILS products, which is the insurance assured linked products, you'll have to go through an approval process through a committee. I think Stuart used to sit on that committee. But very few financial products actually need prior approval in Hong Kong, and for that matter in Singapore or Malaysia. Now, therefore, in terms of the suitability requirements of an institution, how do you know that something is suitable for a client, for example? I think a financial institution may well have to test this, probably through an agency, And I think there will be work for an agency that actually tests this for suitability for clients and give a report actually to a financial institution. Just get in a focus group, like a marketing organization, a marketing consultant. We'll have suitability consultants. So I think there is business in this niche at the moment. I'm not going to start when I'm getting too old for this kind of business. But anyway, I think there is, in fact, potential in them. The other will be, in fact, more disclosure requirements and a much clearer definition of duties. Now, in the United States, in fact, and this is still very controversial, is whether, in fact, a fiduciary standard should be imposed upon broker-dealers. A fiduciary standard is already imposed upon advisors at the moment. The question is whether broker-dealers who consider themselves to be execution-only people. But the question then would be, a lot of broker firms do send out research which says buy, hold, sell, and so on. And the question is that advice? And what duties do you have, in fact, towards your client who actually takes a recommendation based on that? So this is an ongoing story. This is not an issue in other jurisdictions at the moment, but this is an issue in the United States, and a very hot issue, which is now still being debated. And once the United States have come up with a conclusion, this might go to the rest of the world. But at the moment, it is a pure US question. Now then, of course, the question would be, how do you sell complex product? Now this product, incidentally, is a DBS product that was sold to one of their clients. And I was involved in a piece of litigation in relation to this product, which is a DBS product, which is complex. It took me actually, and a consultant, my former colleague in the SFC, David White, 5 days to get this done. Read all the documents, get this done. Now, I've been a lawyer in this field for 30 years, and David has been in this for more than 30 years, and it took us 5 days to get this done. Think in terms of the guy who bought this instrument. Now, my two clients who bought this instrument were retired university professors. Both of them have PhDs, one in engineering physics, and the other one in medicine. And both of them highly educated. And they went to a bank, which was DBS, and said, the DBS said, oh, this is a product which will enable you to guarantee that you don't lose your nest egg, because they invested all their retirement money in this, all of it, incidentally, because they thought this was the deposit. Long and short of this, of course, they didn't understand this. This, of course, went to zero because there was a credit event, went to zero value, and we had to sue the bank. So they had no money, so Barbara and I, of course, did that pro bono for them. We didn't have to go to trial, and in the end, we sent this to the SFC. The SFC, in fact, got a settlement out of them for all the clients who bought this product. They paid 100% on this. So both of us didn't actually get our any fee, but we got tea in the Luk Yu tea house from our client. I'll tell you about the story of the Luk Yu tea house in future. It's also another story. But anyway, looking at these instruments around the world, we'll find, in fact, again, an essential template. We'll find, in fact, in the US, we have, of course, the new FINRA rules. This is the Financial Industry Regulatory Authority, which, of course, looks at the whole financial industry in the US. This is the essential SRO, took over from the NASD. And they have issued, in fact, a new regulatory notice last year, sometime May last year, which went into effect, in fact, later in the year, in terms of suitability and know your client requirements. We'll come to that in a moment because that actually represents an important template. Now, the ESMA, which is the European Securities Markets Authority, they've actually done a review of the Markets and Financial Instruments Directive, which is, they call this the MiFID in Europe, which again follows essentially the same kind of thinking. In fact, we'll come to that very briefly in a moment. The HKSFC, the HKMA have issued new codes, in fact, very soon after the financial crisis, 2011. And we'll touch upon the code in a moment. IOSCO, in fact, which is the world body that sets standards for the securities industry has issued, in fact, suitability requirements, in fact, for some years now, and they now have a final consultation report last year. Now, all of these rules and so on, I've put into the materials, which will be in the website. So I hope you will find them useful. Now, looking at the FINRA rules, one very important thing about the FINRA rules is this. Whereas previously, people look at know your client and suitability as being more or less the same thing. But now, of course, it's become very clearly it has to be separate. Now, in the MiFID, it's regarded as completely separate. And it's very, very important in the European jurisdiction that these are separate issues. Know your client and suitability. They tend to be somehow sort of converge into one thing. You fill in one form, which includes know your client, which includes suitability, and so on. Now, in fact, in MiFID and in Europe, you can't do that. You have to treat these as separate issues. And the reason why you have to treat know your client and suitability as separate issues is these. Know your client is a fundamental relationship with your client. Before you take on a client, you have to know, in fact, his situation, whether this is a real guy or, in fact, not a real guy or a shadow, whether, in fact, you are money laundering for him. And that is very, very important. And particularly, anti-money laundering has now gone to the forefront of compliance. And it will go to the forefront of compliance, in fact, particularly in the United States, as you can see the Standard Chartered, HSBC problems and so on. In the UK, you have similar problems, and you have terrorism around the world, even Chinese banks, in fact, operating overseas. In fact, particularly in the United States, have to be very, very careful about our entire anti-money laundering system, which forces us, the Chinese banks, as well as every financial institution, to treat KYC, that's know your client, as being one of the fundamental internal compliance issues. And I cannot stress this more, because this will be, in fact, a key issue in compliance in the future. Not only because you have to understand your client, his financial circumstances, and so on, but because, in fact, you know that this is actually a kosher client, not some guy who is laundering money for somebody else. Now, there's a recent case in Hong Kong, which was actually in the High Court a few months ago. This young guy who's 21 years old, he was actually putting $50 million a day buying stocks. 50 mil, Hong Kong, buying stocks for like 200 times, and in the end, he was investing like 1.3 billion Hong Kong dollars. Now, what kind of KYC do you have as a broker firm on this one, or a bank for that matter? Now this is a real issue, I think, for jurisdictions. I think particularly like Hong Kong, where we have a lot of clients from the mainland. Heavens knows whose money they're spending or using. And this is, in fact, one of the basic issues that we have to look at. And in fact, I would even imagine that one of the reasons why, in fact, property prices are so high in Hong Kong is because a lot of money has come into the Hong Kong markets, and people don't ask too many difficult questions about them. Now, so KYC and suitability are two separate issues in the regulatory system, particularly in the US. It has now gone to Europe. It will come to Hong Kong. And I'm pretty sure it will come to China, particularly, in fact, with the anti-corruption atmosphere, which the new Secretary General, in fact, has started. Now, but that is very, very important, particularly for people who are practicing in the markets to know. The other question why suitability is a separate question is that it has a different temporal dimension. Why it has a different temporal dimension? Because you buy stuff all the time. And today, tomorrow, later on, and so on. And every time, actually, you buy, you have to relate this to the knowledge of the client's financial circumstances, and also the difficulty of the instrument, his understanding, and the risks. Which is why, in fact, KYC has different dimensions to suitability. Now, this template, which was really a very good note by FINRA on this, and I recommend your reading this. This is 1102, and it's in the course materials. And it will show the way to other, in fact, jurisdictions when they look at KYC, when they look at suitability. And in fact, MiFID also, the ESMA has also done a very good note on the MiFID consultation, essentially going to the same thing. Essentially, KYC and suitability are two different issues. You have to look at them separately, and you have to look at them very carefully. Now, you have, of course, particularly in the MiFID, the question of classification, which is very important. In the US, you have classification of professional and retail investors. In the MiFID, you have three classifications. You have retail investors, so-called intermediate investors, and the other called eligible counterparties, which are financial institutions. They're called ECPs. Now, forget ECPs because they're easily recognizable. The question is, who is a retail investor? Who is an intermediate investor? These are important classification questions because intermediate investors could also include SMEs, small and medium enterprises, not the major enterprises. Now, one of the big problems, in fact, in the UK and in Europe is, do you protect small and medium enterprises from their own follies or from mis-selling? Now, in the UK, in fact, small and medium enterprises are essentially not protected. And I'll come to that in a moment. Now, but first of all, I'd like to go to the SFC Code, which essentially would be issued in 1911, so it is new, essentially dividing people into the three types of financial institutions, the professional investors, and the retail investors. Those are three classification issues, essentially the same as the MiFID. The professional investors in Hong Kong, in fact, you don't become a professional investor unless you go through, in fact, a very rigorous process. It's not because you fall within the defined categories that you are a professional investor. Before you can be one, you have to sign a form. You have to fully understand, in fact, your position. And this has to be reviewed on a yearly basis. A lot of firms, particularly a lot of private banks, fell behind this a few years ago. And they had to be dealt with by the SFC. Now, in fact, they're much wiser, and they do an annual review of this. And they have to make sure that the portfolios don't go down under the $8 million. So private banks now are much wiser. They spend much more time in compliance. The other, of course, are the high-level principles, which I'm sure you're all aware of. But the question, again, goes back to the question of KYC and suitability. As a retail investor, you actually have to have suitability questions. Now, if you are finally classified as a professional investor in the Hong Kong system, the seller does not need to look into suitability. But then the seller has to be pretty damn sure that you fall strictly within the definition of professional investor before you can do that. The other thing, of course, would be the various codes have been changed. Again, the question would be, they do still fall over the cracks because at the moment, of course, you have regulation by the HKMA, you have regulation by the Insurance Authority, you have regulation by the SFC. So the three organizations at the moment, in fact, look at things a little bit differently, although, of course, they say that they regulate according to the same codes and the same standards. But then you have different staff, different ways of doing things. Then, of course, disclosures would be very, very important. You now have things called KPSs. The advertising guidelines have been reissued. Ongoing disclosure guidelines have been reissued. And, of course, you have cooling off periods. One of the very interesting thing, which was actually asked for by some of the people who bought the Cheung Kong hotel units. In fact, they were asking whether we could have a cooling off period. Because after they bought this, they said, oh, what on earth did I buy? And I said, can we please have a cooling off period? Which is very interesting. So the idea is actually sort of permeated around society. Now then, of course, there's a need for better communications, without a doubt. So I'll just pass on that. And of course, a need for effective dispute resolution machinery. Now, Hong Kong, of course, we have the Financial Dispute Resolution Council, which Soo Kim is going to talk about later on. One of the criticisms I would make of the FDRC not of SUKEM, but it's really very limited in terms of its remit. It can only do dispute resolution for 500,000 Hong Kong dollars. That's very little. And in fact, it should be 5 million. So in fact, I don't think she has a lot of business at the moment. Yeah. That she'll tell you about it later on. Now, the question then would be civil liability, which is very, very interesting. And you actually have, in fact, a difference around the world of treatment. Whereas, in fact, in the United States, you will find people going after mis-selling using statutory cause of action. The common law is just too archaic, too difficult for people. And there are many laws in the US which allows them to actually latch onto and have statutory cause of action, which enable them, the DOJ, which the SEC, to start these actions and to class actions, very difficult in other jurisdictions. In Europe, in fact, it's been relatively easier. And in fact, SMEs are protected under the European. A lot of them are still not considered to be sort of intermediate investors. Like this case, which I'm sure we have a European panelist who will talk about this later on. But there is this case in the Federal Court of Justice of Germany. It's very interesting, which was decided in 2011, which deals with a thing called a CMS letter. Now, it was very interesting. It was sold to a small and medium enterprise whose CEO has a PhD in economics, actually. And the German Supreme Court, the highest court in Germany, said, well, even though this guy has a PhD in economics, you actually have a responsibility to, first of all, know two things. You have to know your client, to understand, in fact, the risks of that client. You have to make sure, you have to actually decide on the suitability of this SME to buy this. One of the issues in this instrument, and I'll pass along, you read, I'll have a summary of that in the papers. It's actually a very good summary, which I got from the internet. It's a summary by Clifford Chance. And many law firms have actually given summaries of this case. I couldn't find the actual judgment, which will be in German. So I thought the Clifford Chance summary is very good, which I put into the materials. It's very, very simply this, is that it depends on the client will get a payout if the 10-year Euribor is more than, in fact, the 2-year Euribor. Now, which is usually the case, because you have a long-term Euribor, which tends to be, in a normal market, it tends to be higher, in fact, than a short-term. The problem is that after the financial crisis, there was a short-term liquidity squeeze, which is why short-term money, in fact, is much sought after. So the short-term Euribor, in fact, inverted. So which means that you actually have a negative sum, which means it doesn't get a payout. It actually has to pay, in fact, the seller. And okay, sorry. And as a result, of course, you'll find that. Now, the other thing I'd like to, my time is up, I'm told. I'm sorry, but I'll just end with this. I'd like you to look at a number of cases in Hong Kong and in the United Kingdom. And there are two contrasting cases on structured product, which is very, very interesting in Hong Kong. And then I'll contrast this with some of the UK cases. Now, in Hong Kong cases, case was decided in 2003 by Mr. Justice Balmer, called Susan Field and Barbara Asia. Now, this is a case where Ms. Field was a PR consultant, and Barbara Asia was actually a financial advisor, a straight advisor. She bought, in fact, a very complex insurance-related instrument, as a result of which she lost a lot of money, essentially all her nest egg. She went to court, and then the court then said, well, you know, the advice was negligent under common law because there was a duty, in fact, to advise. She was clearly a retail investor, so the court, in fact, not only looked at the common law, but looked at the SFC codes and said that it was incorporated, in fact, into the common law duty. Now, contrast this with another case which was decided last year, in fact, by Mr. Justice Reyes, before he became Professor Reyes. Now, Mr. Justice Reyes, in fact, in this case is by a Madam Kwok, who's actually quite a rich lady who's been doing accumulators with HSBC Private Bank. A very interesting question in there is that an advisory contract or in fact an execution-only contract? And the judge felt that really looking at the contract itself, it is purely an execution-only contract. And she is stopped from denying that this was an execution-only contract. And such advice that the bank might have given, and the bank says, I never gave any advice, I just told you, here are the available instruments, you take your pick. Now this is a little bit cheeky, I think. But anyway, the judge found that the company didn't give any advice. And she was stuck with the advice, execution-only contract. Now a lot of the UK cases, in fact, turn on that. Is that if you have a lot of boilerplate in your instrument, which says that this is an execution-only contract, and the plaintiff, in fact, is a business, then you're done for, essentially. Because under the UK Financial Services Markets Act, only private individuals, in fact, can use the code as a cause of action. Company who actually bought in the course of business cannot actually pray innate the code. That's that. Now that's essentially the situation. Now finally, I want to just deal very briefly with the class actions. Now we have, in fact, in Hong Kong, the Law Reform Commission has published a class action report. And the class action report, in fact, is now before the government. The government has a task force. And essentially, in a class action in Hong Kong, will follow exactly the same thing as class actions elsewhere. You have to pass 5 hurdles before you can actually get a class action certified. And essentially, it's the same thing. You have common issues, and you actually have sufficient numbers. And in fact, this is the best kind of process dealing with that. So what one hopes is that in future, we will have, in fact, these class actions. It will deal with, in fact, the mini-bond issues as a common issue, if we do have one. But I would think that most of the issues, in fact, in mis-selling has been dealt with very effectively by the regulators. In the mini-bond issues and in the DBS issues, the regulators themselves have forced, in fact, the institutions to make reparations, or else, in fact, they have the license lifted. And the institutions have capitulated. Now, that has been the template, and I think that will continue to be template rather than getting into expensive litigation. Well, thank you very much indeed. Sorry for the time.